Anybody ever entered into a finance contract for a TV or a couch or something like that at, say, Harvey Norman or Dick Smith or anything? Got a nod over there. Are you Jacqueline?
Yeah.
Nice to meet you. Thank you for your email. Anybody else? Okay. So these are less common, these are highly regulated. This kind of contract now is highly regulated under the Australian consumer law, and then far from perfect still. The scenarios essentially goes like this. Mr. Knight decided that he wanted to buy a TV. So he selected a TV at a store, and it was essentially upsold, by the sounds of things, by the salesman who said, well, you can get this bigger TV and we can offer you finance for it. So the finance was actually offered by a third party, so not the store itself, but a company called Latec Finance, Latec Finance, and the documentation was structured as an offer. So essentially, Mr. Knight filled out a document that basically said, Dear Latec Finance, I offer to borrow insert amount here to finance a television, and I'll make these repayments over this period of time, and the interest will be this, and all filled out by the salesperson. So basically, he's making an application for finance, and it's phased as an offer. So now, why would this Latec Finance's standard form? Why would they formulate it as an offer?
They have the option to reject.
They have the option to reject, and I think that's the really important thing to understand in unpicking how this case works. So basically, they returned the form. Mr. Knight signed the form, which would, once accepted, his offer accepted, would create the contract. Had all of the terms and conditions in it. So, and as we remember, an offer needs to be capable of acceptance on its terms without variation, so that once we've got that acceptance, we've got a contract. TV gets delivered to his house, or he put it on the back of his bike, I don't know. He decided when he got home that he didn't like it after all. So he returned it to the shop. Simultaneously, over the 7-day period that Latec had said on its own form that it would accept his offer or reject it, in their own processes, they looked at his application, thought he was a credit-worthy gentleman. I'm imagining a big stamp with accepted on it, went through their own process, but there was no communication back to Mr. Knight. A couple of months, possibly a couple of years later, I don't remember, Latec come and said, come on, we've advanced this money, you need to repay us. They probably did advance the money to the shop. I don't know whether they got that money back or not. I'm kind of not interested for the point of this. And Mr. Knight said, well, actually, I didn't have kept the TV. I don't need to make any repayments. And my guess is he didn't come up with this himself, but his friendly consumer lawyer said, all he did was make you an offer, and you didn't communicate acceptance to that offer. No contract. So what do we think? We think, yes, that poor finance company is being ripped off. We need to find an exception to that. That's what you're thinking, isn't it, Chef?
Oh, no, I wasn't. But...
I know there's all these public access lawyers in this room. I need some of you to get hard-assed and commercial. Come on, who can come up with some sort of argument for Latec Finance?
There was an option.
An option? What do we know about options while we're at it?
Oh, not too much. We haven't done it yet.
Actually, we kind of have as we go. Oh yeah, not really. We do come back to them. You need consideration for an option, separate contract. So I think that would be pretty hard.
Why couldn't Latec said, okay, we're going to communicate it through his dad? Because he hasn't communicated that he doesn't want the contract.
True. They have claimed on it already though. I'll quote here and here. SJ?
Yeah. I think you could make the argument that even though he returned the TV was still delivered to him, and the acceptance of that delivery at the door, that conduct could be
And that is
conspicuous.
actually the kind of argument that they ran. It's a little bit muddled though, because we're muddling up the difference between the offer and acceptance. I'm asking a hard question here because I know you've all read the case. You know that Latec lost. And this is one of the reasons I like it, is it's such a clear indication of, well, this is what the rules are. And I like it too because it's kind of shoving a man to a certain extent. It's essentially saying, well, if you're going to manipulate your documentation to take advantage of the way offer and acceptance works. So, as, I want to say Marcus, but it's wrong, it's Michael. Mike, as Mike said earlier, it's so that they could reject the offer. If they want to take advantage of that, well, the corresponding obligation is that they have to do their bit to properly accept as well. And I kind of like that myself. Jack, I jumped in over the top of
I
you.
think I kind of figured out, I was going to say, does he revoke the offer when he returns the TV? Or is the offer the contract he signed?
I think he could. I think he probably should have revoked it, actually. But at the end of the day, I think the offer probably lapses at that point. And I think Michael's idea is probably the closest thing. If they'd been smart, they would have communicated their acceptance and then come across with the warrant for the outstanding payments. If they'd been evil and smart, like sometimes evil people are like clever as well. But that would have been a smarter way to do it, is to close the gap. Not all of you will be on the side of good, Not all of you. Hopefully most of you will, but not all of you will. So, we need to make it a fair fight. So basically, this is a New South Wales Court of Appeal case, so it's not particularly high ranking, but I like it because of, for the reasons that I've just said. And I think it gives us a good understanding of how commercially that offer and acceptance process plays out.
Persuasive only.
Sorry?
So persuasive only.
In Victoria, yeah, it's persuasive only, absolutely. I think though you'll find, do any of you use Jade? Yeah, a little bit. In fact, I've got Sue and Yap from Jade coming in to talk to us on week 7, or the week after the break. I'm not sure what number that is, but it's worth actually doing a citation search. I just find Jade easier to do that. But I'm sure Osley would do it just as well, to see how often it's cited. It's regularly cited by the High Court as well. So it's quite persuasive, I would say. It's a good description of what the law says. Ultimately, contract sits in this private law space. So the parties can, provided that they pay tax and they don't hurt each other, and subject to any legislation, the parties can work out what their own rules of the games are. Own rules for the game are. They can decide that they don't need to communicate acceptance. But the offer needs to clearly state that. If you're going to move from the general rule, then you need to clearly state it. One of the things I will get you to do when you do your next assignment, don't panic, just do this one first, but I will be asking you to look at a template contract, and in particular to look at the boilerplate provisions within a template contract and think about where those provisions come from. One of the most common provisions that you will see in a template contract is a choice of law clause, not choice of law, sorry, you'll see those as well. You'll see a notices provision. And the notices provision will usually say things like, if a party gives another party a notice under this agreement, it'll be deemed to be, usually, if it's sent by mail, it will be deemed to be received 3 days after it's posted. Now, why do they say that? Because people don't want notices to be deemed to be sent the minute they're put in the post office box. That creates risk. It creates a little bit of risk on both sides these days, because how do you prove something, you know, unless you send registered mail or whatever, how do you prove when something went in the mail? It opens you up to this kind of risk. Notwithstanding what we see in the Electronic Communications Act, it will say that, you know, emails are deemed to be received consistently with the Act at the time that they're capable of being read by the receiver. But then usually, in commercial contracts anyway, time will be deemed to things can only happen in a business day, which is usually somewhere between 8 and 6 on a day when banks are open in the place where the recipient lives. So if I send somebody an email at 10:30 at night, the document would usually deem the receipt to be 8 a.m. the following morning. Now, if I send it at 9 p.m. on a Friday night, that's likely to be 8 a.m. the following Monday morning. Because the parties are setting up a kind of framework for working out how they're going to communicate with each other and what's going to happen. And so, again, and this is what Jacobs is saying here, private law, this is what contracts are for, so people can set up their own hierarchy. But if you're going to do something different from what the law says is the bottom line, you have to articulate it really clearly.